by the working group is to talk about studied law diligently and in good faith by the number of credits needed to be completed each year. For law office study, putting some parameters around studied law diligently and good faith by having the supervising attorney or judge attesting that the applicant is demonstrating sufficient academic progress to continue from one 6-month period to the next 6-month period, which is kind of how the law office study cadence is throughout their study. Also a recommendation to delete reference to the LLB, the Bachelor of Law degree. LLB degrees have not been granted in the United States since the late 60s, the early 1970s. But what undergraduate institutions have started granting is something called a Bachelor of Arts in Law degree. So that's an undergraduate degree. And it would be better to delete this out since it's not something that's granted and hasn't been granted for a long time in the United States in favor of a more professional JD degree. But we wouldn't want there to be any confusion with folks who have that undergraduate Bachelor of Arts in Law degree. In the statute, limiting references from examining committee to state bar when we talk about registering as a law student, since that is done by the state bar and not the examining committee. And then rephrasing how registering as a law student beyond 90 days, like when would that be permitted? Also adding to the statute about distance learning and remote modalities. Right now in the statute, it just talks about correspondence, but we do allow distance learning and remote. Okay. The first year law students examination, that's rule 4.55, adding the word entire to part of how we look at the exemption to this, to the first year law students examination. So we add the word entire, saying your entire first year has to be at an ABA or Cal accredited institution to be exempt. Also adding something from the statute that states that if an applicant has passed the bar examination of a sister state or of a country in which the common law of England constitutes the basis of jurisprudence, they are also exempt from the first year law students examination. That's something that exists in statute and is not actually reflected in our rules. In statute, we added, you will remember, we added, and we actually also need to delete it from rule 4.31. We added the pandemic related reference to an additional attempt. So the June 2020 first year law students exam was a remote exam, pivoted immediately to remote. And then the court added that folks for whom that was their first attempt, a first eligible attempt, where you usually have 3 attempts to take and pass the first year, they added a 4th attempt. But because of time, all 4 of those attempts have now passed. And so deleting out that at this point in time makes sense because it's no longer relevant. There was also a CBE motion, historical motion from 20 years ago, but in the working group discussions, good to bring back around to stay the number of eligible attempts for someone on active military service. So if they get called to active duty, they don't have to worry about taking and passing their first year law students exam and missing their eligible attempts. So bringing back that to recommend as a legislative priority. We talked about this a lot in 22, the 5-year rule, the rule 4.17 about the bar exam score expiring. What we're bringing back in this package is deleting the reference to clear and convincing evidence, not having that evidentiary test for the applicant asking for an extension, just a showing of good cause. There's also an attached policy, and I cut and paste the sentence here for you. I don't need to read it all to you, but a proposed CBE policy that you can think about and making your determinations for those rule 4.17 extensions, that the committee won't issue an extension because the applicant delayed steps. They won't refuse to issue that extension because they delayed the steps to complete the requirements, as long as they left enough time. So as long as the applicant left an objectively reasonable amount of time to complete the remaining steps and try to complete those steps before their exam expired in the 5-year period, that should be some sort of guiding principle for the committee. So we wouldn't refuse extensions where you can see that the applicant was leaving enough time and a reasonable amount of time to get with everything done before it expired out after 5 years. Also, just that one small change, but helpful change about not talking about the last day of the examination, but looking at the 5-year period from the first day of the bar exam, since that's the same for all applicants. The general education rules, pre-legal and legal education certification is referenced in the rules, but there was actually a December 2004 committee policy motion about kind of spelling that out more. What does it mean to be certified for the bar exam? So law schools, if you're in your last spring semester and you don't have your final official transcript, your law school certifies that you are going to have a JD conferral and that you can take that July exam, for example. That's one certification process we have. We have pre-legal certification processes that are more spelled out, certification for the first year law students exam. That's all added into the general education rules. There's a March 2013 committee item interpreting the Business and Professions Code where it says 2 years of college work, that can be interpreted to also mean graduate level coursework. There are schools and countries where you can actually start a master's degree or a PhD without having undergraduate qualifications. So having applicants that come in, if they get that graduate coursework verified and evaluated, and it is seen as equivalent to college work, then we would accept that under the statute and put that into the rules. Also recommended is adding a credit calculation for a 6-month period of study. Right now, the current rules only contemplate a 1-year period of study for general education. And then that one of the definitions about what is a year talks about a calendar year minus 1 day for law study. Taking that from the Rule 4.3. 4.3 is all about definitions and actually moving it into this area. And then repealing this kind of duplicative policy about what constitutes a year because it's already in the rules. The start over process. So there's been a CBE policy since 2004. It was modified in 2007. It is now just on a form called the Start Over form, and that's where you can find that policy, not other places on the website currently. So the working group discussed the process at all. Should we allow students to start over? They start their law studies completely over, kind of this fresh start. Should we limit how many times a student can start their law study over? And in the discussion, it was decided that the students, the consumers, they can decide if they want to start their law studies over. They have available disclosures. They can look at bar pass rates. They can look at graduation, retention, persistence rates at schools. They can be informed, and it would be maybe too paternalistic to limit how many times student can start their law studies over. So we're keeping the start over process, but putting it in the rules, not just on this policy on the form. And so that's folded into the rules in what is attached in this item today. Evaluation of study completed or contemplated. This is something that our eligibility team does a lot. So it is taking this process for folks who want to say, if I do this, will it meet this? So they're saying, if I take these courses, will it meet the study of law requirement? Will it meet the bar exam requirement? Will it meet the first year exam requirement? Or I've already taken this, can you look at it for me? So we have a lot of potential applicants asking for their study to be evaluated. So the rewrite here kind of makes it a lot tighter, explains how they can submit those evaluations to the Office of Admissions. This is for general education or legal education. And then any of these proposed plans of study submitted after the initial one should be accompanied by a fee. We do have folks who do right now submit again and again asking for us to evaluate. It does take staff time. So any proposed plan after the first one would be accompanied with a fee, and that fee is attached in the schedule of charges and deadlines. The working group met about foreign educated and foreign barred applicants a lot. We talked about this quite in depth. You might remember we have these guidelines for foreign educated general applicants with a first degree in law. You might remember because we last talked about them in June 2021, talking about this requiring 20 semester units and 12 of those need to be bar tested subjects, and they have to be in an LLM program. We do have, not a lot, but we do have inquiries from applicants saying, why do I have to take these in an LLM program? The most recent conversation I remember having is there's this Afghan lawyer program where a lot of these Afghan lawyers have LLMs, do not want to get a second LLM. And so part of the guideline modification, which is actually going to put that into the rules, is to allow a non-degree seeking path. So if you want to take these 20 semester units, 12 of those needing to be bar tested subjects, non-degree seeking, we would be okay with that. They would be the same subjects, but maybe for cost, or maybe just because you've already have an LLM, you don't necessarily need to get another LLM degree. And that could be a small barrier removed without any material difference, since the education and the coursework would be the same thing we're already looking for. Another review from prior CBE motions, we looked at this 2015 motion to allow applicants with refugee status to petition the committee for a waiver of their documents, so they can register as a foreign educated law student, sit the bar exam, or if they're licensed as a foreign licensed bar applicant. We have had over time, a lot of refugee petitions saying that it's very hard to get their certified documents if they are refugees from their home jurisdiction. So putting that back in the rules from that committee motion from 2015. And then practicing without restrictions. So I think this was another 2013 guideline looking at whether or not foreign barred applicants have any restrictions on their practice. So can they practice without restriction in front of the highest professional bar admission regulation or licensing authority? And it is difficult looking at all the different certificates of good standing or certificates admission sort of worldwide, and we need to have some sort of standard. And we did have this guideline before, but the actual final approved guideline left the part out about the highest professional bar admission regulation. And that the ability to practice without restrictions. We just need, the recommendation is to put that back in, because it is difficult sometimes, and we had issues in the past with like a patent attorney is not the same sort. Their practice is not, as with many restrictions, is not the same as other folks who can practice without restriction in their home jurisdiction. So just adding that back into the rule set would be a great clarification and transparency for what our eligibility team is looking for. I showed these already. How about any questions that we can discuss so we can tee up things for the next meeting?
I have a few, but let's others go first.
Audrey, can you hear me okay? I do have a question about the 5-year expiration on passing bar exam score.
Yes.
I think my understanding is we're changing the rule from clear and convincing to good cause. I think that's a new standard. Am I correct?
I've already said good cause. It's deleting out clear and convincing evidence.
Okay, got it. And my understanding is, and I think this is also in the agenda item, which is that the Supreme Court denied the request. But am I correct, at the time when the Supreme Court denied that request, it actually had the, if it still chose, it could have revised or amended our proposal to whatever that is that it sees fit? I mean, am I correct that Supreme Court actually had the ability to do that, but it didn't?
Oh, that it could have taken our red line with the red line. Yes, but
Right.
it was just a very, I think a one sentence.
Yeah.
Yeah, no.
I think my only concern here is the Supreme Court has already spoken on this issue, and somehow it sounded as if we're still trying to have a second bite of the apple and trying to defy, the court's, directive on this. I don't know how well it will play out. That's really my concern. And I certainly understand the overall sentiment among the committee members, which is that we really need to give those people a chance to, present evidence to demonstrate why they missed the 5-year expiration dates. At the same time, I'm just mindful that the Supreme Court has already spoken on this issue, and if we were to do something more than that, then we run afoul of running and just putting ourselves in a place where we might not want to get into.
Well, I think there may be some room between the basically unlimited time we were proposing to give to them and clarifying our rules to create, for instance, safe harbors. I was very much against what the committee voted to do, but I remain concerned that if we just leave the rule the way it is, we really have no guidance, and we're basically just subject to emotional appeals. I would prefer to have clearer rules with less need to interpret every case. For instance, this idea that they have to take, they have to make, I don't like the term objectively reasonable, but they have to file their moral character application in such a time that, if everything goes as staff promises for the regular case, that they would, get it completed within the 5 years. I think that's fine. But then it still leaves in the good cause requirement. And I was told that removal of the phrase clear and convincing evidence was designed to make to liberalize our ability to grant extensions. And, I'm not really keen about that personally.
Yeah, I think
Yeah.
I have the same concern. Yeah, Rule 4.17 is pretty clear that, and with the Supreme Court being so, from our perspective, it's pretty clear what the Supreme Court wants. You have to satisfy all your requirements within the 5-year limits, meaning that there's no other way to go around this. There's no design around, there's no alternative. Whether or not you have excuses, you still have to meet those requirements within the time limit set forth in Rule 4.17. But now we're carving out an exception where, well, that depends, right? If you have some good cause, perhaps you could get away
That
from
was
that.
already in 4.17 about the ability to when we can extend, right?
Oh, I'm sorry.
Yeah.
Yeah. May extend this 5-year limit for good cause shown by clear and convincing evidence. But I think that the point remains that this is a very high standard. Clear and convincing meaning there's there's irrefutable proof, right? This is the highest standard of proof, that you have to have some good cause shown instead of just minimal evidence that demonstrates some excuse or justification.
Yeah, I don't recall us ever really agonizing over the quality of the evidence when we've considered these things in the past.
Right.
It's just been about, is the story compelling? Does it pull at our heartstrings? And I'm just uncomfortable with that whole approach, because I think there's a real danger that we will give inconsistent results depending on the quality of the the storyteller as story, and maybe even our own mood at the time we make the decision.
Yeah, and
So
good cause sounds like, to me, it's like one of those preponderance standard, right? It just, it's not, the level is so low that basically anything that seems reasonable would be sufficient to get to warrant the 5-year exemption. And I don't think that's what the spirit of the rule indicates or what the Supreme Court wants. I mean,
I think
clearly
that's why the policy was drafted, and maybe that's where we could put effort into tightening the policy for how the committee can decide to make those extensions for good cause.
Yeah, but to the extent we can kind of come to some kind of sense of what we want to say today, I think it'll make it possible to come back with something in June. Otherwise, we may be having this, another debate in June and have to come back in August with the final. Although if the board sticks to their policy of only considering proposals twice a year, maybe that doesn't matter.
Mhm.
Well, I
Um,
know there were folks who were on the original 4.17 working group as well, who might want to weigh in on good cause. They have proposed policy, striking through clear and convincing evidence, so that could be helpful.
Yeah, I'm actually okay with with this one carve out to say that if you get your moral character in, I mean, I would want to clarify it a little bit. And I think it'd be better to say like at least a year before the deadline expires, rather than just say objectively reasonable period. Um, and if the delays are not the fault of the applicant, yet it just because it takes staff time, more time than expected to complete the review, that I'm perfectly happy to say, we'll extend it to the extent necessary for staff to complete their review. If we do that, though, we have to make it clear that if somebody gets sent off to lab or, is in abeyance, that at that point it effectively is a negative determination, and we're not going to extend it for a couple years so they can get therapy or whatever else they need. That's just my opinion. Any more thoughts about that particular issue? Okay, another issue I see that I wanted to, it, there's when we define somebody's diligence, in several places we say that they have to complete their coursework, no quicker than maybe 48 weeks, and no slower than 52 weeks, something like that. I agree that we should not let people accelerate their legal education, to like try to complete it within 3 years or something like that, because that tends to or could dilute the quality of their education. But I don't see why we have to say that they can't take longer than the minimum time to complete, a year's worth of study. For instance, let's say somebody is going through their first year at one of our regulated schools, and they have a big health problem, and so they have to drop out. But they can come back, say, a year later, and just complete the second half of the second semester. Why shouldn't they be able to do that? They're going to have a complete year. It's just going to take them a little longer. They're obviously going to have to take 5 years instead of 4 to get their JD, but I don't see why we should say they have to throw out their whole first year worth of study if they can't get it done, within a year. Do you understand what I'm saying?
I do, but I think something like that would be something separate, like a leave of absence provided for in the law school rules, separate to what we're looking for in eligibility about law study completed in the sorry, it's actually in the guidelines. I just thank you. Someone sent me a note. So in the unaccredited guidelines talking about leaves of absence or things that we need to have the year defined for eligibility, because we're looking at the 4 years too, right? The 4-year rule for law office study or our registered students, looking at what is a year, and now we're looking at spelling out what is a half year, because that's how those transcripts are read and interpreted by the eligibility team.
But I'm not sure why we have to say what the minimum period is. I'm still not sure why we have to say what the maximum period would be. And I don't think our eligibility rules are modified by the standards we apply to law schools.
What do you
in
mean?
the legal sense.
Oh,
Anyway, we can talk about it later.
Having a standard unit of what a year is good for a lot of reasons, but yes, we can talk about it later.
Well, I think we're maybe just causing people trouble. Maybe there are no such cases. And then I'll just say that at this point, I don't understand the modifications to the family code, but I'm also not convinced that we couldn't do that and shouldn't try to enforce family support obligations via our regulatory levers. Maybe it's inconvenient, but the legislature, obviously think that's an important way to enforce. Is it currently the case that if somebody is on the list, we just won't let them become a member of the bar?
We hold them off the motion to be certified if they appear on that certified list of tax, or child support arrears.
Okay, and I think the thought in granting a temporary license is that it would allow them to earn the money necessary to satisfy their obligations. So why is that not a good thing? Again, aside from the inconvenience to our system.
I think the position we were looking at with the working group is that the license to practice law is it's a different sort of license that has, the public has an expectation, for the ethical conduct and the financial obligations that someone who has a license what that represents.
Okay, so it's a temporary moral character hold.
I mean, they're someone's falling behind on a financial obligation. I think that we're looking at it through the lens of public protection, what that might mean for the trust of the public of issuing those folks a temporary license.
So they might raid the trust account to pay their family support obligation? You're worried about that?
There's also a perception, I think, as well of allowing those temporary licenses for people who are behind on financial obligations.
Does the medical board take the same position?
Issue temporary licenses? No.
They don't?
I don't know if I don't know exactly in these situations. I don't know that at what situations the medical board issues temporary licenses.
Need Dr. Cow.
Yeah.
Okay. Well, what I can say is in this staff report, right now it just makes the assertion that it would compromise public protection, but doesn't explain how. So I hope we have an explanation that is more complete when we go to the legislature and ask them to grant us this dispensation. Because I don't think they're going to say, well, I know they won't say trust us, or they won't accept trust us as an explanation. Right, Larry?
Jean was off mute. Did you want to say something?
I was just going to say, Paul, I'm not sure if you're aware of this, but Family Code Section 17520 already references the State Bar of California. So I believe part of the intent here is to codify that in our rules. And Audrey, you can correct me if I'm wrong on that.
No, we're proposing an amendment to the Family
carve out
Code.
to the Family Code about those issuances of temporary licenses.
And in the carve out, it says, but for purposes of other licenses, we will honor that requirement. And I was wondering what other licenses would those be? Legal specialization? Are we going to withhold renewals of those for this? We can talk about it later, but I just wanted to highlight that as I have let's say a lot of concerns or questions.
Mm-hmm.
And I shared them with Audrey and Donna and the working group members last night. And I'm presuming that we're not going to be able to get this in final shape today, and there's going to be another round. So what I'm planning on doing is perhaps even getting myself into the working group, but having a discussion with staff and them about all the things identified. Some are just correcting errors or places where there's duplicate statements to the same effect and other things. But those are I think what I've spoken to today are the questions where, if there is input from the group, I was hoping to receive it so that, we have a better chance of coming back with an approvable product at our next meeting in June.
And Audrey, I have one concern that I think it's really worth our time to talk more, and that is on the changes to legal education. Let me know if I'm mistaken here. I think the proposed changes here is well, the current policy is that, and this is, I believe, what the California called the apprenticeship option, where you don't have to go to law school and you can just, work at a firm or a judge's chamber and whatnot. And so right now, the current policy is, every candidate has to diligently and in good faith, right, for 4 years study at a law school, right? That's the current policy. And the proposal by the working group is to eliminate the duration, right? Take out the 4 years. Am I correct?
No. It's just because studied law diligently in good faith doesn't have a lot of parameters. So it's just
Okay.
it's to create, and it's in there. It's actually a proposed new rule about for law office study in particular. What does studied law diligently in good faith mean? We do right now. We've had supervisors who say, on the exams that they give their supervisee, that they are not passing them, but there's no mechanism in the rules, because they're still studying diligently, but they're not
Yeah.
doing well. So that's a disconnect, right? So
Right.
having a supervisor actually attest saying they are making academic progress, they are moving along in this course, that I have set out for them, that would be something that would show us that they are studying diligently in good faith. And that's what that is about. It's about putting some shape to what that means, especially for law office study, because right now someone could be failing these, 6-month exams that someone's giving them in their chambers. And then it's like, well, you tried very diligently, and that's not probably the best way to interpret that.
Got it. No, I certainly understand. It's very subjective, and so we're just basically converting it into something more objective from which to measure the performance. I guess that's why I'm glad you clarified, because I thought just looking at the staff's recommendation, it appears that we're taking out the 4 years, but it's not the case.
No.
Okay, got it. So we're still keeping the 4-year requirement.
Yeah,
but
and that's statutory as well.
I'm sorry. Come again?
That's statutory. Sorry.
Okay. Yeah, understand. And then we're basically asking the supervisor, the judge, to report about those progresses on a 6-year, every 6 months.
Yes, exactly.
Got it. Makes sense to me. Thank you for clarifying.
Yes, thank you for asking.
Okay, any other thoughts or concerns that would help the working group in its continuing review and revisions to the proposals? Okay, do you need anything else from us, Audrey, at this point?
Well, David, would you accept Paul into the working group?
No,
I think
I'll keep them down to 120 words or less per comment.
We all fail.
Okay, correct me if I'm wrong then. I don't have my file up right now, but I think we have covered all the open session items. Am I correct?
You are correct.
Okay, so that means it's time to go into our closed session.
People need a 5-minute human break before.
Yes.
Sure. So let's let me say all the magic words, and then you guys can start your break. So we are going to go into closed session to consider the closed session items on the agenda. We will return to this open session at the end of this afternoon's discussions, simply to report that we have finished the closed session And if we were to have any items to report out of it, we would report them at that time, but I don't expect to have any to report. And then after we return to open session, we'll be adjourning that or recessing it until tomorrow morning to facilitate another closed session for the purpose of selecting questions for the July bar exam. So let's take 5 minutes and be back into the closed session at 3:35. And again, we will keep this open session Zoom meeting open for the purpose of coming back out very briefly at the end of the closed session. Okay, everyone. This is Paul Kramer reporting that we just concluded our closed session at 5:04 and that we have nothing to report out publicly as a result of the closed session. Because we have a meeting tomorrow to pick questions for the July bar exam, we will be recessing this meeting and this open meeting until 9 a.m. tomorrow, Saturday, the 22nd of April. But when we do come back at 9 a.m., it'll only be to say hello, and then we will move to a closed session. And just like today, we do not expect to report any results out of that closed session when it concludes. So with that, we are recessed until 9 a.m. tomorrow. Thank you.
Thank you.